Please get serious course materials.
Is that different from what was it, registration?
No, this is the same stuff.
Yeah, that's online. I downloaded.
Oh, this is for all the committees. Oh, isn't
Yeah,
that
they
cute?
Do the whole lot. Yeah, that's why they insist.
Oh, I thought it was because I had what my I had what my former teacher used to call logorrhea.
I downloaded the whole thing into my computer, so I have it.
That's good.
Perfect, you can listen.
It's an excellent choice. Okay. Not bad. 5 minutes late. That's pretty good. In case anybody wants subsequent testimony, this is tea because my voice is shot. I'm completely dry today.
Is it Long Island tea?
No. I grew up on Long Island. This is Manhattan tea. Have a seat, Mr. Khan. You can sit right here.
It'll be more conspicuous when I leave.
Yeah, well, that's okay. We'll forgive you.
Hey,
Okay.
I'm down here. I need 2 books.
2 books.
2 books.
2 books.
I need one. One for him, one for me.
Truly remarkable. I would like to point out that this is probably the most well-attended committee meeting we have had since my involvement in the section, which started.
You don't have to.
2000, no, not that long. 2006 or thereabout. 2005. I want to go over a couple things first, but I want everybody to introduce themselves so they can claim that they know everybody the next time they see them. We will start on my left with Mr. Khan, who had the unfortunate experience of spending Sunday night with me.
Jay keeps saying unfortunate, is actually quite nice. Hi, my name's Greg.
Is-
Greg Hahn. Oh,
Whatever you want. Say whatever you want. What you do for a living, your favorite wine, your favorite baseball team. I'm not. Just introduce yourself.
my name's Greg Hahn. I am a lawyer, it turns out, at Clifford Chance. My favorite wine, we'll say, is either red or white. Not really, no.
No. Go ahead.
My name is Francisco Oxbach. I'm an attorney as well. I'm a solo practitioner, and I'm proud to say in this meeting that I'm from Argentina, where we make Malbec.
He mentioned that because he knows that it's the only grape I don't like. We've discussed this. Go ahead.
My name is Pam. I am a newly admitted attorney, so relatively new to the field, and I'm hoping to start with Benua and their arbitration team soon. And my favorite wines, I tend to gravitate towards Malbec and Cabernet.
Hello, good afternoon, good evening. I'm Cheryl Kinch. I'm a solo friend, and I have quite a bit of compliance, sort of securities background for law school. I'm looking to build out a new practice area, and I thought this would be a good fit for me, particularly on the regulatory compliance side.
Because you don't drink, right? You did say that to me.
I don't drink, so I think I will really be good at this
Yeah.
area.
I am Barry Wadler. I'm a solo practitioner. I'm a member of the business law section and also commercial and federal litigation because I do a lot of complex litigation. I've represented beer distributors for a number of years. I'm trying Israeli wine tonight because I'm inspired because I'm going to Israel when my daughter gives birth, which is any moment now. Thank you very much. My first grandson, and I'm heading over as soon as I get that call.
Bring warm clothes and rain gear. The weather is horrible.
So she tells me.
Yes, it's awful. Drew?
I'm Drew Jaglin. I'm the current chair of the business law section, and the former chair of the international section. I actually practice in this area as well. Barry and I have run into each other on occasion. I represent some beer distributors, some craft brewers, some spirits distributors, some wine and spirits importers, some soft drink bottlers. If it's wet, I deal with it. I am drinking more and more cocktails lately. bitters and whiskeys and gins, so, but I'll drink anything that's red.
I'm Jake Cook. I might be the only one here that's not an attorney yet, but it's because I'm in my third year. So I've been working for a firm that does a lot of commercial transaction work in Albany, and we do a lot of licensing stuff, and I interned at the SLA, so that's something I want to get into, so it's a good opportunity to come meet the faces. It's one of the first meetings, so.
My name is David Oppenheim. I'm a shareholder with Greenberg Traurig. My specialty is franchise licensing and distribution. Occasionally, I'm asked to handle wine and spirits matters, whether it's distribution agreements or relationship issues. I had the pleasure of also serving as the chair of the business law section. Everything I learned from Jay Hack, so I thought this was a great opportunity. I did. I thought this was a great opportunity. Anytime, what I did learn from Jay is that anytime Jay is serving wine, that's where you want to be. So here I am. I'm really looking forward to it. I think this committee like this is long overdue, and I think we're going to have a lot of fun.
My name's Clive Anderson. I suspect I'm the only barrister in the room. As you can hear from accents, I came from England many years ago. I was 20 years a partner at Morgan Lewis, and I went to be working in Russia, which is what I've been doing since then, representing companies there and individuals anxious to get their money out, which there are many.
Steve Forte, attorney, New York, for Hopper Thurman. I have mostly a litigation background, but been getting into the franchise area. I work with Tom Pettigoff, I think some of you know. Thought it'd be a good idea to come and share him.
I'm Pedro Paz de Almeida. I'm a Lisbon partner at the Lisbon law firm, a large law firm.
Oh, we need to
Lisbon,
talk
Portugal.
then?
Sorry?
We need to talk afterwards. My wife wants to go there.
Be my
Next
guest.
week.
I'll be happy to help.
Yes, babe.
And of course, I joined this section 2 years ago, the business law section, and before, and I still continue to be also a member of international law section, where I became a member many years ago. And of course, Drew made me promise that I will become a member of this section, so I always keep my promises. And the promises I will be making now is next time you will be having drinks, I will bring some wines from Portugal.
Pedro also is the former president of the UIA.
Oh, you were the one.
Yes, I
thought I read.
Nice guy. He's unduly modest in leaving that out.
Yes.
I'm Mark Schwartz. I know nothing about wines. I'm a fairly decent real estate lawyer and securities lawyer. We have a small firm around the corner on Madison. Jay, I want to thank you for your commitment and your leadership in this event.
Avril Shatloff, and I'm mainly in the securities area. Through the years, done a number of transactions with restaurants, restaurant chains, wine and liquor importers, things of that sort. So this would be interesting view as to the nuts and bolts, because I tend to see the actual businesses that have the licenses as we talk about financing.
Hi, I'm Teresa Massaro. I'm an Italian lawyer. I have no practice in the city. I'm here as internal from internal law here.
Hi, my name is Chris Scott. I am also not an attorney. I'm sure you're the only one, but I work with.
Then get out. Then get out.
Wait a minute. Are you 21?
I'm 21. Yeah, I'm 21.
Can we see proof? Can we see some proof?
But I work with our client that works in the wine business, so I think fairly more interested in learning.
Hi, my name is Luca Milconna. I'm an Italian and an American attorney. I'm based here in New York. We represent importers, distributors, and producers, and this is what we do every day, so we're really interested in seeing this meeting taking off and of course participating actively in all the changes and the contribution that we can do in the legislation or in any direction we can give to the state of the art of the industry. And I want to thank again Jay for putting up these, because this is a great opportunity to contribute in some way.
Hi, my name is Asher Rubenstein. I'm one of JHAC's partners here at Gallant Dryer and Berkey. Half my practice is asset protection, tax, and estate planning. The other half of my practice aligns with what I like to do when I'm not in the office, which is food and wine. I represent wine importers, restaurateurs, and other people in the hospitality industry. And Jay and I, just today, after 6 months of negotiations, we finally culminated a joint venture where our clients are going to be importing sochu and awamori from Japan, the first major venture in that realm, bringing Japanese spirits to, non-whiskey Japanese spirits into the US. So welcome.
My name is Matt Carroll. I'm an attorney at Goldenbach Eisenman, which is just right around the corner. I do mostly corporate law, M&A. My firm has a very big hospitality practice representing celebrity chefs and restaurant groups, both independent and private equity backed groups. We don't have our own liquor lawyers or franchising in-house. We partner with other firms to do that, but thought this would be an interesting opportunity to meet other people in the industry.
My name is Nick Sarad. I'm a partner at Bracewell here in New York. My connection to the wine industry, other than drinking wine, is that when I was a law student, after 2 years at Berkeley, where the law school was this little nest of right-wing conservatives as a sort of oasis around the liberal Berkeley, where I felt alienated in that right-wing crowd, I decided that the only hope that I had to finish law school was to get away from it for a while. And I told myself, if you leave law school and don't do something that looks meaningful, maybe you can't get back in or you can't get a job afterwards. So what am I going to do that's interesting, that's connected to the law? So I said to myself, what I'm going to have to do is I have to get a fellowship to study wine law somewhere. So that's what I did. So I got a fellowship to go to Paris, and I studied European Community Wine Regulation for 1 year, between second and third years of law school, and did a lot of drinking. I went to the first ever international symposium of the law of the wine and the vine, where I met a lot of wine producers, including the guy who ran the house, which is called Domaine Tempier, who was one of the first people that Kermit Lynch met, the guy from Berkeley who now is also making his own wine in France, and fell in love with the industry and whatnot. That year I came back and became a project finance lawyer and did a little bit of wine-related things for a while, and then kind of got away from it, and I figured after 30-some years it's time to get back into it, so here I am.
By the way, if you try the Domaine Tempier Rosé, you'll change your view of rosés.
Yeah. But you gotta ask, never mind. We know every lawyer in New York who drinks wine, and one of them is a fanatic about how horrible Tempier is. So go ahead.
My name is Daphne Chen Matthews. I have 20 years of experience in banking focused on regulatory compliance, risk management, and conflict resolution. I'm currently looking to transition into an industry that can use regulatory compliance lawyers such as art, wine, anything like that. So, oh, and my favorite wine is Riesling and Vino Verde.
Riesling fan. Well,
Bola Suave Bola.
No. Vino Verde.
Or is it Bola Suave?
My name is Marge Gross. I am a bank regulatory lawyer, but my nephew runs a whiskey. My nephew runs a whiskey tasting bar in Boston. I decided I should know more about the laws and regulations that govern him.
Brava.
Marge is way too, would we say shy or? Modest, much better term. Modest. Let's see, you're currently the head of the are you currently the head of the ethics committee?
No, I spent 3 years as chair of the
ethics committee, but more importantly, has had various fancy positions, which we won't specify, and very high levels of the bank regulatory process. We'll leave to her the opportunity to tell you what they were, maybe. Go ahead.
I'm Joyce Hanson. I've spent my career as a lawyer at the Federal Reserve Bank of New York. And on a church board in which I've served, a number of licensing issues came up over my time there, including our attempt to prevent an adjoining property owner from obtaining a liquor license. So I thought it would be interesting to become a little more familiar with some of these issues. And my favorite wines are the Argentinian Malbec, but also the Chilean Carmenere.
Wow.
No Chileans here?
And I'm Mike DeFreitas. I am a lawyer in Buffalo where I have a small business and tax practice with a lot of regulatory issues involving, including a lot of nonprofit organizations, speaking of churches. I think the regulatory aspects of this are really interesting, but I really wanted to join this committee because being first generation Portuguese, my family made wine in Madeira for many decades, and I just couldn't resist the opportunity to learn more about this area of law.
Can we have the next meeting there?
Well, that's okay. That's a perfect transition, okay? Because I'm going to transition from I'm Jay Hack and I am a bank regulatory lawyer. I'm going to talk about how this committee came about and some ideas on, and you'll see it's a good transition. This committee started because I am unfortunately a member of the Bar Association's House of Delegates, and they have a dinner after every House of Delegates, in the middle or the night before, I forget, of every House of Delegates meeting, and they serve really, really bad wine. So for the last few years, every meeting, I have brought a case of my own stuff. And it got to the point, honest to God, where people would call me or send me emails a week in advance of the meeting saying, are you going? If so, can I reserve a seat at your table? At the last meeting, which was in November, someone, I think Kathy Scott, who's supposed to be here, but she might have to be late, commented that we really should have a liquor law, substantive law committee of the business law section. So I took my name tag, scratched out business law, and wrote liquor law section on it. And then took a poll, and of all of the polls and posts that we made on the business law section community, there were more responses to this one than like numbers 2 through 7. So the business law section executive committee voted in November, I believe, to create the committee. And because I got tired of people saying to me, you know, we really ought to have a committee, I said, and no one else was going to do it, so I said, why not? So we have a committee. I am the chair by default. I would love to shed that position. There are a variety of reasons why I want to shed it that are technical, related to the Bar Association's bylaws. I will not tell you what they are, because then you will not volunteer to take the position. But I am really trying to get off the Business Law Section Executive Committee, and every time it's, what's that?
From Al Pacino.
Al Pacino. I'm channeling my Al Pacino.
Bring it back in.
Every time they pull you back in, right? Anyway, from the point of view of committee organization, I spent much more time on this than I probably should have. I think that there are 4 different substantive areas, probably more. And yours, and going to Madeira is the 5th. Okay, anybody have any Madeira older than 1875? 1875 going once, okay, I do. The 4 substantive areas, it seems to me, are New York State regulation, federal regulation of the federal process, not interstate issues, interstate issues, and international importation issues. And I think that there's 4 groups. I'd really like to have 4 subgroups, or at least 4 people who will take responsibility for presenting information about those topics to the group. because I think that it naturally makes for CLE topics, 4 different CLE topics that covers an entire year. The 5th subcommittee, I think, needs to be the, call it what you will, the travel subcommittee. I know many different alcoholic beverage producers in various parts of the world. I know that Asher does. On Sunday night, I sat at a table with Herr Selbach from Selbach Oster, who makes, his family's been making Riesling since for 300 years. And there were a lot of other Riesling producers there, and we know a lot of people all over the world. So I think that finding similar law interest groups around the world and the possibility of travel. My wife, if I can get her to not fully legally retire as an attorney, might be willing to work on that committee. But that's committee group number 5. So what I would love to have volunteers who are focused on any of those areas, who would like to do as much or as little as they. I'm not big on rules and pushing people, but I would like to, except for my employees. I don't want to lie, but I would like to. You don't have to volunteer right now, but if you're interested in any of those topics and would like to take some responsibility for just putting some materials together, and we'll blow it out to everybody, and perhaps organizing an event or two focused around that topic, I would really like it. Now, that brings us to the administrative stuff is. In order to get CLE, you must sign in and you must sign out. So if you have not signed in, please do so. I'm going to pass this around. If you don't want CLE, I don't care, sign anyway. I don't want to, it's a whole big thing. It is important that we establish the number of people, regardless of whether they actually want CLE. So if you haven't signed in yet, sign in, and if you're not on the list, just write it in here. No, go here, otherwise I'll lose it. Write it down here. Okay, now, as we go around that, I'm now gonna give you some information on the current state of litigation in the federal courts regarding interstate wine issues. Now, I'm gonna stick to principally the 2 big Supreme Court decisions. That was the Granholm case, which was decided in 2005. I apologize, some of the material says 2004. Somehow I picked up a typo, it's my fault. It was in 2005. It was Granholm versus Held, which was the governor of Michigan. It was actually a dual case, Michigan and New York. And then last term, we have Tennessee Retailers versus Thomas. I'll explain what those cases were all about, but that's what I'm going to focus on. I had the opportunity to really seriously dive into the Dormant Commerce Clause, which I knew about maybe this much. It's fascinating. Marge, from a banking standpoint, it raises some, it really is dry. I haven't figured it out yet, but I've got some troubles with some banking decisions based on these. The linkage is unbelievable between one area of the law, a totally irrelevant area of the law, but interstate banking and interstate liquor shipments raise a lot of the same issues. But anyway, here's the point. And I will open with briefly a quote from Benjamin Franklin, who thought that wine was proof that God loves us. Now, the critical factor here, and that a lot of people forget.
He also threw a metal kite in it.
Yeah, he didn't. That's the urban legend. Before there were urbans. The 21st Amendment includes a very interesting second paragraph that a lot of people don't know is there. Everybody thinks 21st Amendment, they repealed prohibition, done. The second paragraph says, this was the states' rights paragraph, and based on my research, it's a political trade-off. the transportation or importation, two key words that the courts ignore, the transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. Early on, that was interpreted to mean if there was a state law that made it illegal to get alcohol into the state, the 21st Amendment trumped everything else in the Constitution. However, as cases evolved, the court, we were debating this during our negotiations today with the lawyer on the other side, just academically. The court either realized the absurdity of that absolutist preemption position, or the court, which is my view, or the court decided to ignore the true originalist intent of the drafters of the 21st Amendment and just said, nah, we don't like the idea, so we're going to interpret it some other way, which is what the guy across the table from me felt. This is all based principally, not entirely, principally on the Dormant Commerce Clause. For those of you who don't know what the Dormant Commerce Clause means, I mean, back me up to Tennessee retailers, I figured it out. The Dormant Commerce Clause is basically a legal argument that since Congress is given the authority to regulate interstate commerce, states can't adopt statutes that adversely affect interstate commerce, even though Congress has not acted in that particular area. And the Commerce Clause at that point is no longer dormant. It wakes up and says, no, you can't do that because you are regulating interstate commerce, and since Congress has the authority to do it, you can't. So that's to quote Judge Alito in Tennessee Retailers. Any of you people know Keith Levenberg, by the way? Come on, Asher, you know Keith Levenberg. He's an attorney who was in New York, practiced for a while. He's now in D.C. He was Judge Alito's last law clerk before he was appointed to the Supreme Court, and is also a wine collector, and probably wrote this. Under our Dormant Commerce Clause, if a state law discriminates against out-of-state goods or non-resident economic actors, the law can be sustained only on a showing that it is narrowly tailored to advance a legitimate local purpose. In other words, in the balance between the 21st Amendment provision and the Commerce Clause, the 21st Amendment provision cannot be used to beat up out-of-state producers or out-of-state actors for the benefit of in-state actors. The position of the judges in the majority in the recent cases basically is, Mississippi, Alabama, there were about 9 states that did not ratify the 21st Amendment. Those states, many of them were dry. Mississippi was still dry until 1980s, 70s or 80s, I forget. Those states, you don't want to...
There's still states with dry counties.
Yeah, they still have dry counties. Those states, if you don't allow your local people to do it, you can't be forced to allow out-of-state people to do it, because that's what the 21st that was what the 21st Amendment second paragraph was intended to deal with. However, if you allow your in-state people to do something, then it's not because you're regulating demon rum, as they referred to it at the time. It is because you want to take a protectionist approach, and that violates, the unfair treatment violates the Commerce Clause. There's, occasionally you get in, you find equal protection arguments, you find privileges and immunities arguments, but they're always part of, it's like a substantive due process, I guess, analysis. I'm going to drag in some other related stuff. but it's principally the Dormant Commerce Clause is the argument. Now, the first 10 or 15 years post the adoption of the 21st Amendment were fairly absolutist, and then the cracks started to show. The first case, which will shock all of you, it was a Supreme Court decision 76 called Craig versus Boren. Interestingly enough, Oklahoma allowed women to purchase 3-2 beer. Everybody know what 3-2 beer is? Dean's
Near
nodding.
beer.
What?
Near beer.
Near beer. 3-2 beer at 18, but men had to be 21 to purchase 3-2 beer.
Ooh, makes sense.
What, they wanted to get the women drunk?
Yes.
So really, that's
And-
what
and-
is,
and the-
that's
and-
the
and
only...
the men couldn't be trusted.
Right, that's the only way I can explain it. Justice Brennan, one of my heroes, who was appointed to the Supreme Court by mistake, by the way, said that the 21st Amendment does not save invidious gender-based discrimination, his exact words, invidious gender-based discrimination, and that the Equal Protection Clause of the 14th Amendment trumps the second paragraph of the 21st Amendment. And rather interesting because Oklahoma had advanced a non-discriminatory, non-commerce clause argument for why women should be protected, men shouldn't, or vice versa. I don't know. It was all a lot of hooey. The court said, no, 14th Amendment, you lose. Then we have, and this case, by the way, has nothing to do with transportation or importation. It has to do with internal use. But they spent a lot of time talking about 21st Amendment. Then we have the next case is a court case called 44 Liquor Mart versus Rhode Island, 1996. What happened was, and this is again a case that they ignore. As I read the statute, I said, remember the words transportation or importation, because for a variety of reasons, including pre-prohibition statutes and the like, the transportation and importation paragraphs language is not that important to the court. In Rhode Island, they prohibited liquor stores, etc., from advertising the price at which liquor was sold, and they prohibited newspapers from stating the price at which it was sold in an article. So even in a narrative, it was illegal under Rhode Island law for a newspaper to say, hey, this is unfair to our people because you can buy a bottle of Popov vodka for $1.29 in Massachusetts and it costs $1.79 in Rhode Island. That was illegal, clearly illegal under the statute. You couldn't put a price in a newspaper article. Justice Stevens then, writing for the majority, basically said the same thing with respect to the First Amendment that Brennan had said with respect to the 14th Amendment. He said, we hold that the 21st Amendment does not qualify the constitutional, qualify meaning limit, in that sense, the constitutional prohibition against laws abridging freedom of speech. The 21st Amendment cannot save Rhode Island's ban. I thought, frankly, that was a slam dunk because Rhode Island's ban had nothing whatsoever to do with transportation or importation. It was an advertising prohibition, but they lost that issue. I don't know, I read the decision a couple times on Sunday, and I can't figure out why. So there were, according to, then we move forward to the Granholm decision in 2005. The decision was written by Judge Kennedy. What he did was, first he says there were 3 different categories of court decisions pre-Granholm. One is state laws that violate other provisions of the Constitution, 14th, 1st, etc., are not saved by the 21st Amendment, number one. Number two, Section 2, the relevant provision we're talking about, does not abrogate Congress's Commerce Clause powers with regard to liquor. I think that's, yes, there are decisions to that effect. And it's maybe pushing it a little bit. But yes, the courts were so holding. And number 3, state regulation of alcohol is limited by the non-discrimination principles of the Commerce Clause. And he went back and he looked at, and it's rather interesting, there's a couple of Federalist papers that are writing, at least one by Hamilton. I'm sorry, I tried. I got some quotes on it. I saw the original with Lin-Manuel Miranda like 2 weeks after it opened. I tried to channel him so that I can't do it. I was going to read the Federalist paper that way, but I just couldn't do it. But Hamilton and Madison both wrote that the problem with, and I didn't realize this was all a great history lesson for me too, that one of the biggest problems under the Articles of Confederation was the states feuding with each other and adopting protectionist legislation to limit interstate commerce. And that was a major reason for the Constitutional Convention that resulted in the adoption of the Constitution. And both Hamilton and Madison made it very clear that congressional, having nothing to do with liquor, obviously, but they made it very clear that congressional supremacy with respect to interstate commerce was really, really important, and that it was their view that the lack of it under the Articles of Confederation was what was about to rip the non-existent Union apart, because the states were at war with each other over commerce, not gun war, but they were at war with each other over interstate commerce, and they were about to walk away, and they felt that Hamilton and Madison felt that the congressional supremacy under the Commerce Clause was one of the most, if not the most, substantive provisions of the Constitution. So that's where we are when we get to Granholm in 2005. What happens? Michigan allowed in-state wineries to ship to Michigan residents. Michigan did not allow out-of-state wineries to ship to Michigan residents. New York, in the companion case, luckily, it's just called Granholm, so we forget that New York was just as bad, although Drew and I disagree on this point. New York required that, because New York has a 3-tier distribution system, New York permitted local New York State wineries to ship direct, gave them a home farm winery exemption, but New York required that an out-of-state winery deal through a New York distributor in order to distribute their wine in New York. So the court analyzed it and determined, I think it was pretty clearly, that the purpose of the statute wasn't protectionist. The purpose of this was protectionist. The purpose of the statute was not to exclude the demon rum from their citizens. They didn't have, the legislature had no problem with citizens using alcohol, and what they didn't want was citizens using alcohol from out of state without paying more for it. And as a result, the specific question upon which cert was granted was, does a state's regulatory scheme that permits in-state wineries directly to ship alcohol to consumers, but restricts the ability of out-of-state wineries to do so, violate the Dormant Commerce Clause in light of Section 2 of the 21st Amendment? That was the exact language, the exact question upon which cert was granted, and the court goes through a rather fascinating historical analysis. This is where, I mean, I didn't read all the Federalists just to find Hamilton and Madison. I think it was in this decision, although it might have been one of the others. The court concludes that the purpose of the Michigan and New York statutes was to grant in-state wineries an advantage over out-of-state wineries. There's a lot of economic analysis there. There's discussion about direct-to-consumer sales. The court talks about the increased volume of direct-to-consumer sales. The court talks about the increase in number of winery licenses. I believe in order to have a winery license to produce, you have to get it's a federal license. There was a substantial increase. I forgot to write down the numbers.
You have to have a federal basic permit to wholesale. I'm not sure you have to have one to produce.
If you have to have one to
You
produce
certainly don't
more
as a
than a
brewer.
certain,
Yes.
it's more than a certain amount.
As a brewer, you don't.
Yeah, but they concluded that, I'm sorry, the number of winery permits was way up. The number of distributorship permits was way down. There was a major FTC study on the subject, which they quote from at length, and they commented, and here is where Drew and I disagree. The court commented, small wineries are shut out due to their inability to provide sufficient volume for a distributor to be interested. The countervailing argument, which Drew first made to me, and I've been talking to a lot of people about from my people in the industry, the countervailing argument is that the small wineries can't get their product on the shelves without a distributor who's hawking it for them, because if they just sell, if they're selling without an intermediary, somebody to carry their flag, how is a guy in, a small producer in California going to get 50 liquor stores in New York to carry his product? That was not the court's focus. The court's focus was DTC, direct-to-consumer sales. And ultimately, the holding, the court said that in all but the narrowest circumstances, state laws violate the Commerce Clause if they mandate, here's a quote, differential treatment of in-state and out-of-state economic interests to the benefit of in-state interests. Later on in the decision, he says that differential treatment is quote, virtually per se a violation of the Commerce Clause. But note that Granholm and the New York case are both winery cases. They are not retailer cases, and they have generally, although a lot of people said, well, what's the difference? It was limited to wineries. Now, and by a lot of other decisions, said, well, we're not sure, and it got litigated, and it's being pushed up. Then we have last year the Tennessee retailers. I just call it what?
Total Wine.
No, the plaintiff is Tennessee blah 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 Retailers Trade Association blah blah, but everybody just calls it Tennessee Retailers versus Thomas, which is the Total Wine case. Total Wine, thank God they're not ruining the market in New York because they just sell track, but that's another story. Garbage. We'll keep it clean. Total Wine wanted to open stores in Tennessee. Tennessee had a law that said that the holder of the license must have been a resident of Tennessee for 2 years. Tennessee also said that if it is an entity that is the owner of the license, all officers and all directors of the entity must have been residents of the state of Tennessee for at least 2 years, which the court mentions as an aside, but later on when I talk about one of the other cases, it's like they didn't notice. The court, in its decision, sort of says, oh, by the way, that virtually prohibits public companies from selling liquor at retail in Tennessee. And then goes on with the analysis and doesn't otherwise comment on that. And Judge Alito now recognized that this isn't, in my view, this doesn't touch on transportation or importation either. But everybody's focusing on the 21st Amendment as as effectively an abrogation of congressional power over this issue. And Judge Alito, not known for his anti-states' rights and pro-federalism positions on other issues, but note his relationship to Keith Levenberg, the wine collector, who was his law clerk, not at the Supreme Court, said because Tennessee's 2-year residency requirement for retail license applicants blatantly favors the state's residents and has little relationship to public health and safety, it is unconstitutional. Now, I know we're all New Yorkers, or at least we're close enough, but you remember that Tennessee is this big, long, skinny state, okay? And he discusses the fact that Tennessee argues, you know, we want people from the same community who understand community standards and who will moderate the nature of their business to the community. And he points out that it's 500 miles from one end of Tennessee to the other, and there is no reason, I can't remember the town he used. There's a town at the west side of Tennessee on the border where the town on in the state right across the border has the same name. I
Bristol.
don't. What?
Bristol.
Is it Bristol?
I think so.
Yeah, I think you're right. So he says there's no reason to say that a resident of Nashville who owns a retailer in a retail store in Bristol knows more about the community standards in Bristol than the guy Tennessee than the guy right across the border in Bristol, whatever it is, Kentucky, or I'm not sure. I'm a New Yorker. I go by the famous New York Magazine map.
Saul Steinberg.
Yeah, right. We understand. But and goes through, and what actually happened, and the interesting part about this is the Tennessee Attorney General agreed that the statute was unconstitutional and wasn't going to enforce it, and announced that they were going to grant the licenses to Total Wine. And then the Tennessee Retailers Trade Association, and a lot of this stuff comes down to Retailer Trade Association doing the litigating. Tennessee Retailers Trade Association litigated again and sued their own attorney general to stop him from issuing the license. And the court says no. And Alito has a lengthy historical discussion, and he says, removing state trade barriers was a principal reason for the adoption of the Constitution. Under the Articles of Confederation, states notoriously obstructed the interstate shipment of goods. So that was why, he was here, I made the note here. The Hamilton Madison Federalist Papers quotes, what a shock, it was Alito who's sort of an originalist. Alito was the one who wrote about Hamilton, Madison, and the Federalist Papers. And he said that an attempt to distinguish between out-of-staters and in-staters was no good. Now comes some more interesting, now comes the recent litigation. To give you an idea of how, I don't know whether it would be fair to say us lawyers manage to churn cases, or give us an idea of how government officials like to ignore the ignore court decisions until they get whacked over the head. We have two interesting recent cases. We have Walmart stores, which is December 2019 decision of the circuit out of Texas. Texas has a law that says public corporations can't obtain package store licenses. Walmart sort of has the economic clout to be able to litigate the issue. Walmart goes to court again and sues the state of Texas to invalidate the state law which refused to give Walmart a license because Walmart's a public company. the district court holds that the public corporation violates the Dormant Commerce Clause. Well, yeah, okay, that's what they said as an aside in the earlier Supreme Court decisions, but we're gonna let, they want it anyway. So what they do is, and I guess this is a matter of the way litigation is, why I hate litigation, it's like you gotta play this game of the rules of who decides what. They remand, the remand is warranted for reconsideration of whether the ban was enacted with a discriminatory purpose. Court points out that 95+% of all of the companies in the United States who have liquor licenses, public companies, are not located in Texas, and therefore it has a substantial exclusionary effect. But the court remanded it for factual determination regarding whether or not it was in fact a discriminatory purpose. After Walmart, knowing full well that that was what they were, they're likely to do, bombarded the court with a lot of legislative history. I think they had some emails from legislators, speeches from legislators, to establish to establish that there was a discriminatory purpose, and to establish that the stated health of the local citizenry purpose was a total sham, and that everybody knew it was a sham, and that the trade association came up with it as a talking point. But the court said, no, we're not going to make that finding. They remand it back, and I assume it went back to the district court. The decision is barely a month old, so I did not follow it up. Then we have the related decision, which is kind of messy because they say it's before Tennessee Retailers was decided, but cert had been granted, and the court notes that Tennessee Retailers might answer the question of whether Tennessee Retailers was the out-of-state shipping case, out-of-state retailers case. Remember, Granholm. Yeah, Granholm was an out-of-state winery case. Tennessee Retailer, for those of you who are familiar with this is my partner has asked me, who has no interest in this committee. He said, all I care about this committee is you got to make it legal for K&L in California to ship wine to me, because I've been buying from K&L for 20 years and they won't ship to me anymore, which is true. Why won't they ship to them? Because I think the Attorney General and the SLA sent a letter to all of the major retailers that did a lot of interstate shipping and said, don't you dare. And I've seen the letter, and some companies said okay, and some companies said sue me. K&L, a very active and big business, didn't want to waste money on legal fees, so they said okay, and they stopped. So Lebemoff refuses to license retailers without an in-state presence. So if K&L had a store, a bricks and mortar store in Chicago, then they could get a license, and I believe that they could ship directly from California, but they have to have a bricks and mortar location in Chicago. The court had some trouble with the Supreme Court's decisions. He says, the court said, drawing lines that are sometimes difficult to follow. After I read them a couple of times, I think I figured it out, but it has decreed that states may not infringe upon other provisions of the Constitution under the guise of exercising their 21st Amendment powers. On the other hand, I would like to hear what is the difference between a retailer shipping interstate and a winery producer shipping interstate, whether that is a distinction that rises to constitutional level. I have a lot of trouble with that, but they're litigating it. The case, my comment here in my notes is the rhetorical question: why doesn't Granholm answer this case? It would be kind of fun if I think there's a cert petition pending. I had some trouble trying to find it. but I think it would be kind of fun for the Supreme Court in the cert petition to write, why are you wasting our time? Read Granholm and go home. Which they will do about once every couple of decades when they get really disgusted, having heard an issue in a case 10 times. And they're getting close on this one.
Not if Clarence Morris becomes Chief Justice.
Excuse me?
Not if Clarence Clarence Thomas becomes Chief Justice. He's persistently in the minority.
Yes, I should note that Clarence Thomas has written dissents in both of these decisions. They are very lengthy dissents. I give him credit for well-reasoned analytic dissents with a lot of information. He takes the position, which was the position taken by the other side of my argument this morning. He takes the position that in the Webb Canyon Act, which was the pre-Prohibition Act, that was statute that was trying to protect the states, and then a variety, and the real purpose of the 21st Amendment, he said everybody knew at the time that the purpose of this was a trade-off to allow the state to regulate liquor within its borders, period, and the Congress was giving that up. And the arguments that were made regarding the repeal of the Prohibition Amendment were simply, we can do whatever we want in our state, but it's not for us to regulate other states, so we should repeal Prohibition, and if other states want to let their people get drunk, that's their problem. And there was some reasonable support for that proposition. The interesting thing is that there are two different methods of amending the Constitution. We all forget about method number 2 because it's only been used once, and that is for the repeal of the 21st Amendment, which is that states can approve repeal either through a...
I'm sorry, the repeal of the 18th.
I'm sorry, I said it, yes. Yes, the 18th, not 19th. 19th was, yeah.
And suffrage.
Yes,
It
next
hasn't been repealed yet.
August. I'll show you my photograph of the 50th anniversary March, my favorite
Well,
photo.
if Trump gets reelected, you know.
Yeah, you never know, that's true. But no, what,
Repeal the whole Constitution.
I'm sorry, I lost my train of thought. What was that?
Second means to
Second
strike down amendment.
Second method of amending the Constitution.
Oh, the second method of amending the Constitution is by a variation of a plebiscite. And in most cases, if not all, I'm not sure, there were votes in the states to create to create conventions to approve the amendment. So effectively, the people who lived in the state elected representatives who then had a convention and voted for repeal. And there were more than half, there's about 10 states that did not repeal. Most of them are, those states that I don't visit. No, there's states, Alabama, Mississippi, South Carolina, North Dakota, South Dakota. There's a couple of those kind of stuff, but generally they are states that were historically pro-temperance states, and they never ratified. The total ratification, I believe, was there were 2 states that ratified it within a couple days after the last state that did. I don't remember the exact date. I had it written down.
So it was December 33.
Right. There was December. It was December 7th of 33, and One state ratified December 8th, another one December 10th. So they were 2 over. And then there were 2 more significantly later on that, even though it was irrelevant, went ahead and ratified. But that's it. And it was contentious, and Judge Thomas clearly feels very strongly that the court is out on a limb, because his originalist approach says, I'm only, it's no good. And the other thing that's interesting is Judge, I'm drawing a blank. He was the oldest judge in the court at the time. He was 85. Stevens. I'm sorry, you're right, yes. Judge Stevens at that point said, in his, I think, separate dissent says, I'm 85 years old and I remember what it was like. He was 7, I think, but okay, it's good, close enough. I remember what people's attitude towards alcohol was, and the modern attitude that it's just something else to drink was not the common attitude at the time. The attitude at the time was that this is something that's evil, that we want to keep out of our state, but if other states, it was a states' rights argument, if other states want to do this, they can do it so long as we don't have to. However, it could have been written that way. Didn't have to use the words transportation or importation, but it did. And there is an argument that I think Alito makes. He makes the argument that the court's interpretation of the Commerce Clause in the teens, prior to the adoption of the Prohibition Amendment, was so different than it is today, that the reason they worded it the way they did was to overrule, let's say, the court's view, which was, I guess I sort of remember this from law school, it was referred to as the original package rule. So that if a bottle of liquor in its original package crossed the border, it was allowed to cross, and so long as it wasn't repackaged, and the original package sent from out of state into state, in-state, was then delivered to somebody in its original package, states could not regulate that. That was the analysis under the Commerce Clause. And that's why the importation or transportation language was used. I think it's kind of a stretch, but it's an interesting historical aside regarding explaining bad, weak drafting in the Constitution because of weak analysis by the Supreme Court, which has been completely abandoned. Where is it today? There is a proposed statute. It's in the materials. It was drafted by the California Wine Retailers Association. It's okay. I talked to the guy who wrote it. I don't like it, but it's just offends my sense of good statutory drafting. You shouldn't write, a human being shouldn't write like that. I didn't say that.
It's California. Yogurt, sprouts, that kind of thing.
Yeah, that kind of mung bean sprouts. They have a state assembly sponsor. Happens to be my assemblywoman, I discovered. Amy Paulin is the assembly sponsor. They don't have a Senate sponsor yet. They are looking for a Senate sponsor to advance the legislation, and they are getting a lot of pushback from, gee whiz, Southern Wines and Spirits, the king of the middlemen, and to a lesser degree, and I think it's probably not directly relevant to them, but for brand protection and long-term protection. Constellation Brands, which is headquartered in DeWitt, New York, upstate New York. They're getting a lot of pushback from
They're
that.
really mostly in Chicago at this point.
What, Constellation?
Yeah.
Yeah,
Their
it
headquarters
doesn't
are in
make
Chicago.
sense that they're headquartered where they are.
Well, it used to be Almond Taylor and those guys,
Right.
so they acquired all of that, and so they got all of those Finger Lakes locations, but Constellation's based in Chicago
Yeah.
at this point.
However, they do
Certainly the
contribute.
corporate offices.
They do contribute large amounts of money to New York State legislative campaigns. But we didn't mention that because Citizens United is outside the scope of this discussion. Interestingly enough, by the way, and I'm into this for an hour already, so I'm gonna stop. I just wanted to say, I was gonna talk about Wayfair and the relationship between the Wayfair sales tax case and this analysis, but I concluded that I wasn't gonna make it in an hour. But it's rather interesting because Wayfair flips it on its end. Wayfair says state sales tax is enforceable, notwithstanding that the interstate commerce component. But of course, in Wayfair, the state wasn't imposing extra tax on the importation. The state was only saying our in-state tax should be imposed upon out-of-state sellers. But of course, it has nothing whatsoever to do with the 21st Amendment, and it is, the commerce, basically they say it's not a restriction on the Commerce Clause to tax locally because they're not treated discriminatorily, so therefore the dormant Commerce Clause doesn't wake up. Questions, please? No, it was an interesting 6-hour academic exercise early. No, I'm serious. I'm kind of an egghead. I like this. It's like, I judge moot court competitions in topics that I know nothing about just because I get to learn something. I collected all the course materials, but to really get into the weeds and carefully review hundreds of pages of Supreme Court decisions, it was interesting. I should also note...
But don't you think it's significant that this development's really only taken place in the last 25 years? I mean, repeal was, 70 plus years ago. But it's taken a long time for people to wake up to this issue. The decisions that you've been describing are all, as I say, no more than 20 years old.
Well, that's precisely what Thomas is arguing. And what the guy this morning was, the lawyer on the other side, it had nothing to do with this, but I mentioned that I was speaking on the subject, so he wanted to argue his points. He's a spirits and liquor lawyer. It's what he does. What Thomas was saying was, you just made this up recently. The guy this morning, his argument was the court knew. It says in the decision. I'm not so sure because I couldn't find it when I got back from the negotiations. Thomas clearly says that. I don't know that the majority says it. He says, it is very clear that the court knew very well what Congress intended when they drafted, remember, Congress still drafted the constitutional amendment, and what everybody intended when they approved it, and the court in recent years has just decided to ignore it. And his argument was that I don't care which way they came out on Tennessee retailers, but I am offended by the fact that the court is usurping not legislative power so much as a legislative decision-making process. Is the legislature analyzed it, considered it, and adopted statute intending to reach a result, and the court says, yeah, we don't think so. We don't like that result. We're going to rewrite it. I don't think that's what they did. but you're right, it's clear that the dormant commerce clause analysis and just saying that that's effectively the equal protection, that out-of-state entities are entitled to the equal protection of the laws under the Commerce Clause, but we're not gonna say 14th Amendment because that's gonna upset people, is a relatively new invention.
Well, do you think it's related also to the distribution process? I mean, in the 1940s, 1950s, there weren't total wines around the place. And so, in a sense, you bought your liquor from your local store and you paid your price and you didn't care about it too much. And if you went to California, you'd like to buy the wine there and you smuggled it back into luggage, whatever you did at that point. Is this a phenomenon of the fact that liquor has now gone broad scale and there are more commercial interests involved because a Walmart's more interested in doing this than Joe's liquor store on the corner?
Well, I also think it's possibly because of internet commerce.
Yeah.
It has increased, and now like the layperson, like I had a nice wine on a cruise and I want to buy it from Italy, but I can't because I live in New York.
We'll talk.
So
We'll explain it.
Oh.
Asher and I are experts.
Get over it. No, but I mean, I suspect that's possibly it.
There has been,
Wayfair.
well, that's the Wayfair. That's the Wayfair principle.
Was Wayfair the first company to actually litigate this? Because I've heard for years that people were saying, well, we're online, you have no jurisdiction over us.
That's what Wayfair was saying.
Yeah, Wayfair said, Wayfair was, you remember International Shoe? Wayfair was, we have no presence in your state, therefore you do not have jurisdiction over us to tax us. And the court said, sort of, I haven't read Wayfair as closely as these cases, the court said, nice try, not in this millennium or this century, you don't.
It's a new world.
Yeah, it's a new world. I mean, if you think about it, I mean, I bought 3 cases of wine yesterday. Specifically yesterday for a reason, not relevant, but it's the day known as the Black Friday of wine commerce in America. No, the Forbes wrote an article which they referred to. January.
Why didn't you tell us this?
January 27th. You can still get it today. Everybody extend one. January 27th of every year is the Black Friday of wine commerce in America, and I would say 40, give or take a little bit, small producers all offer their wines through a particular wine discussion bulletin board. There is no way. I mean, I was in Sonoma in 1998-ish, I forget exactly when, and I could go around and, take a case and fill it up, but there was no way I would have found the people other than that I was driving up and down the road with my wife going, oh, let's go there, let's go there. Now, I can find every single one of them, and I can order from them.
Right.
And I can look at internet databases that'll tell me what my friends like, what my friends don't like, what they taste like. There are people, you can calibrate your tastes against people you know who like the things you don't like. I calibrate my tastes against people that I know who hate the things that I like. And if they say it's awful, I'm buying it. Really. Speaking of Bob Alford, the construction lawyer in Orlando, who likes, you see, we know, Asher and I know people all around the country, and if you think about what it takes to be a serious wine collector, the basic principle is money, and there are a lot of lawyers who are involved. So we know lawyers all around the country who are partners in big law firms, and we know what they like and what they don't like, and when they're in New York, we have dinners for them, and vice versa. But you can't do that you couldn't do that in the 1990s, let alone the 1930s. So, but if you're an originalist, that's the point. It's an interesting question. I wonder how Thomas decided Wayfair, how Thomas voted on Wayfair. I don't know.
Well, Thomas is going to be very, the EU is going to be very grateful to Thomas, because Wayfair is going to be the reason why Google gets taxed.
Gets taxed in
the
Europe.
EU. And why all the French wines will suddenly face a 25% to 100% tariff coming into this country.
Yeah, and I know a lot of California guys who hate Donald Trump, but they're really rooting for the tax.
Well, no, because the concern is that you're gonna destroy a lot of the restaurants and a lot of the distributors that those California wineries are depending on. The 100% tax would devastate the wine industry,
Oh, yeah, it's-
domestic as well as foreign.
Well, I've been told that there is a really good restaurant in Washington DC near the Senate office building that has a very good wine list, and they have reprinted their wine list, and there are 2 columns: current price, price if the tariff goes through. There's 2 columns.
No, the 25% tariff people are avoiding in a variety of ways. So there are people bringing in wine in bulk and bottling it here because it's only if it's imported in packages of less than, I think, 1.5 liters. There are people who are increasing the alcoholic content of their wine from 13% to 14% because there's a 13.5% ceiling on what's going to be taxed.
It's 13.5?
I think it's 13.5.
Usually, because I know that there was a
between
tariff
13
differential
and
at
14.
14.5, and I have been told by many Italian producers that they're regulators, former regulators. I have been told by at least 3 different Piedmont producers, they just lie. They put 14 or 13.9 on their labels, knowing full well that number 1, nobody tests for it, and number 2, it's about 15.3. And it's frankly idiotic, because you're talking about Bruno Giacosa selling wine in the United States for, his red label is $350 a bottle, and he saves 25 cents, which is the differential. But they do it. The Italians consider it a badge of honor to cheat the tax. Come on. Somebody over here was right, isn't that true?
No, he's going to deny it.
Yeah. It's a badge of honor. Believe me,
For Italians, in a certain sense, yes.
Yeah. I mean, recognize that it was, after all,
it was needed. There's an historical reason for Italians to cheat on taxes.
Yeah. But I mean, Oliver Wendell Holmes, he said it is not the obligation of any American to pay any more tax than they are absolutely, positively required to pay.
It's a matter of saying.
Yeah.
Let's put it this way.
The case I thought you were going to talk about was the litigation over New York lawyers having to have an office in the state in order to practice law here. That's more analogous, I think, than the Wayfair
That's
case.
fair. I didn't think of that, actually, but you're right. But what's the holding? The holding is that they have to have the office.
It's still in litigation, I think.
But the highest decision currently is that you have to have
It
it,
doesn't
right?
violate the Privileges and Immunities Clause.
Yeah.
That's the current status.
But you don't have a 21st Amendment provision.
Which
It's
makes
not, I don't know,
which
his
makes
practice.
it even less.
I'm waiting for some judge to say that the practice of law is not commerce, of course.
It's a profession, right?
Yeah.
It's a calling.
Yeah, I agree. It's one of the, one of the 4 great historical professions, right?
Medicine, theology, mathematics.
Medicine, theology, no, that's the, medicine, theology, law, and teaching.
That's mathematics. Originally,
Was it originally mathematics?
The word mathematics comes from transmitting knowledge.
Yeah, because I know that.
I was always told that the 3 professions that were the same were the law, the clergy, and acting.
No, the ancient professions are law, clergy, medicine, and if you say mathematics, I've always heard it in a way of teaching.
Well, teaching mathematics, nothing else is worthwhile.
No, well, but there's an interesting. let's go. I mean, you want to get really far afield and talk about the relationship between mathematics and ancient mathematics and music and things that I had never, Thank you all for coming. You may now. Iced tea.
You have to collect the green sheets, Jay.
Yes, the green
everybody,
sheets.
everybody please give me a green sheet. And you are welcome to continue to sample what we have in the other room.
Thank you, sir.
And I am sorry that there are actually 3 viewers on the internet, and we're real sorry that you cannot come into the room, my other conference room, and help sample stuff. But when you're in Manhattan, we have a standing offer. Have a nice day. I'm going to shut off the